All right, well, welcome to this week's legislative review. And this session is getting closer to being done. I think we're about 2.5 weeks away or so from it being done, since February is a shorter month. And I think it's common by this time for people to feel a little burnout with things. But we'll go through some of them today. And hopefully everything won't be quite as heavy. I think the bills we have so far are a little bit, not as much, maybe, but some interesting ones to discuss still. So, Jill, you had sent us some. So one of these is HB 441.
Right.
And this is the Franchisee Protection Act. And you were asking if the government should be involved in these types of things with what it's doing here. So I'll share, I guess, the backstory to this bill a little bit. This one was in the news. The franchise or the store called Nothing Bundt Cake, when I guess years ago when people signed up to be a franchisee and they purchased a franchise, it was under the condition that they could close on Sundays, and that was allowed at the time of signing up. And recently it made the news. There was some big waves because Nothing Bundt Cake, the company, said to all their franchisees, we're not going to allow you to be closed on Sundays anymore. And when it comes time to renew your franchisee agreement, which you have to do every, 3 or 5 years or something, it will renew with this provision that you have to be open on Sunday. So this created an uproar among some people in Utah. I don't think everybody had an uproar over it, but there were certainly some row over it. And so Representative Ivory has proposed a bill that would prohibit a franchisor from requiring a franchisee to open on a religious holiday if that conflicted with the franchisee's sincerely held religious belief. But it also puts in exceptions for when a franchisor can require a franchisee to open on Sundays or a religious holiday. So if you look at it, the operative language in this bill is here. If a franchisee asserts a sincerely held religious belief, a franchisor may not enforce a religious day operation requirement, require a franchisee to accept a religious day operation requirement, or refuse to renew a franchise agreement. They can't make them accept it as a part of an amendment to the franchise agreement. But then it goes on to say, but subsection 1 does not apply when the original franchise agreement conspicuously provides a religious day operation requirement. The franchisee agrees to a renewal or an amendment to the franchise agreement to a religious day operation requirement, or the franchisor and the franchisee enter a franchise agreement, expanding the franchisee's number of franchise locations, and that contains a religious day operation requirement. So Jill, I think you were asking, does the government really need to be involved in this, or can parties contract on their own with things? And you guys can certainly share your thoughts. My thought is this is an area best left to the private sector to sort through. If you want to protect your religious beliefs, I think you can negotiate for that with your contract. And if you're specifically signing up because there's not a Sunday operation requirement, then put that in your agreement and say, you agree I don't have to open on Sundays. But it's something that in business, that things can change every time. It's kind of like your lease. If you want to lock things in with your landlord, you sign a long lease, 10 years, but many people don't want to sign that much. And so they'll sign for only 1 year or 2 years or something. And that the landlord can change things at that point when the lease comes up. So I personally don't feel it's super necessary, especially because the franchisor is still allowed to require you to open on Sundays. as long as the original agreement says it in there conspicuously. And to me, that just makes it so that franchisors have to pay attorneys more to make sure they draft their agreement correctly to still be able to do whatever they want to do. But curious if any of you have different thoughts on that. All right. And then we had a request to look at SB 277, Government Records Management Amendments. This one has made it into the news quite a bit. The news, KSL, Fox, others, they're not happy with this bill. And it does quite a bit. You know, as you look here, this bill, it says, has 10 subjects, which is always interesting to me because Utah has a constitutional provision that says only one subject per bill. And so what the legislators' attorneys have interpreted that to mean is, as long as we can say one title that encompasses everything, then that's one subject. But then they openly say, but we're hitting 10 subjects here. And we're affecting 30 sections of code. And these are all the code sections. So it's pretty broad. And currently, under GRAMA, or the Government Records Management, or the Government Records Access and Management Act or something, you can request government records, and there's a process. If the government entity denies those to you and says, no, we don't want to give them to you, you can appeal that. They have a hearing committee. That hearing committee has, I forget if it's 5 or 7 individuals on it, and they will meet and look at the records, look at the government entity. They'll listen to both sides, and then they'll make an order telling the government what they need to do or not do. The government can still appeal that to court, or the person can still appeal that to court, but they meet with this committee first. And he's proposing, he says, you know, this committee is not really experienced. They're a bunch of volunteers. And so we're having him disclose too much, basically. And so I think it'd be better if we had someone that knew the law and could follow the law. So I'd rather have an attorney be the sole person that hears these appeals. And so what he wants to do is get rid of the committee. So it says replaces the State Records Committee here with the director of this new office, the Government Records Office. So he's proposing to create a new office. The director of it would be an attorney that hears the appeals and kind of acts as a judge in it. And so you'd go from a group of 5 or 7, I think it was 7, down to just one judge doing these things and making all the decisions. He feels that will make it more consistent and more predictable. I personally think it will mean it'll favor the government a lot more, because the governor does get to appoint government records and whether you get those or not. The real beef, though, that the news has is that this line item here, it removes the subjective balancing test provisions for determining the confidentiality of a record. And what this means is you could go in front of the committee and say, yeah, that's normally confidential, meaning the government doesn't have to disclose it, but the public interest is so high that you should disclose it anyways, because, you know, we're investigating Sean Reyes or whatever it is. And so the news was able to get quite a few things through this balancing test because there was a lot of public interest or concern over it. He doesn't like that because, again, it makes it so that more government records are being disclosed. And so he's removing that. And KSL and Fox are quite up in arms about this. They're pretty upset by it. And they've talked to him about it. He'll meet with them. He'll say, yeah, it's not perfect, but we got to do something to balance it better. And yeah, we should get something better because we're not replacing it with anything. We should replace it with something. But then the news points out, but he doesn't have anything and he doesn't propose it. So that's the main I'd say the main gist of what's going on with this bill. Again, there's a lot because we're getting rid of a committee. We're taking on a new office. So it's a long bill, but that was in my review of it. The summary was decently accurate on that. But one important thing to look at is at the bottom where it talks about what the bill repeals. We'll see this in some other bills, but sometimes there's just all kinds of things repealed that they don't put in blue line for you, the blue cross through. They just say the whole thing's repealed. So obviously the State Records Committee is being repealed, but there's also this one on evidentiary standards for release of certain enforcement and litigation records. And so this is part of they wanting to release fewer records to us, and so they're getting rid of that provision as well. Are there any questions or comments on this? KSL, I guess one other thing quick is KSL did an article where they pointed out that this session, there are 15 or 20 bills at least that remove different pieces of grammar. This is the biggest one, but there's a lot that take out little pieces. So for example, one of the bills was on the Utah National Guard, and it was allowing the Utah National Guard to now negotiate and have deals on land and water without those being public records under GRAMA. And I look at things like that and I go, land and water, two of the most critical things in the state, and we're going to take away disclosure on those. And so there's a lot of little pieces where they're pulling out pieces of GRAMA, and KSL's article on it said, basically they were talking to an attorney, and it basically said, I'm not a conspiracy theorist, but this sure comes across as super coordinated because every bill is stripping away a little piece of it, and they're essentially gutting GRAMA this session with all these pieces that they're taking. Again, KSL published that, they're upset about it, but I don't think it's really making the rounds. And one reason why it's not as publicly discussed or openly discussed is because they take a little piece here and a little piece there, and that makes it so that people can just go, oh, this is just a little thing, don't worry. But collectively, it's quite a bit. And so we'll have a lot less GRAMA after this session if all these bills pass. But curious again if you have thoughts or questions on SB 277 or some of these other concepts.
I just find it kind of surprising when, I know Adams and Schultz have been saying that they are committed to fixing like our elections, for example, or at least making them more secure. And then
Yeah.
they would go and do this. I mean,
Well,
it's just, isn't it just decreasing transparency?
absolutely decreasing transparency, which decreases accountability. And one of the games they often play is, and the federal government's really good at this. Federal governments are the Congress is a master of this. They'll create a big commotion about one thing, and they'll fight and fight and fight about it, and all the news focuses on it, and they do hundreds of things all together behind the scenes that nobody sees coming because they're just putting all the attention on one thing. So there are a bunch of election bills, and there's a lot of energy and focus from people being put into those, and then they can just disperse the GRAMA provisions throughout 15 or 20 different bills, and
they go unnoticed.
It goes unnoticed because we're focused on elections, basically. But yes, they are pulling a lot from the public records domain, or trying to.
So what do we do? How do we combat that?
Well, there's the KSL article, and one is to share it, and then just go up and say, hey, we don't vote for a single bill that takes things out of GRAMA. I don't care what else is in the bill. Essentially, don't vote for something that's removing things from GRAMA. And I think if we create enough noise about that, where they hear from enough people, they know that they can't move forward with it. Noise does stop some things.
Can you highlight a few other bills that are in this bundle that are, maybe more of the violating
Yeah, if someone wants
factor.
to, while you're here, you could go to KSL and see if you can find the grandma article. It was from maybe a week ago.
Okay.
And then we can share
So
it in the
they
chat with
highlight,
people.
did they highlight it?
Yeah, so
They
KSL
did
went
that.
through
They
and
did.
called it
Okay.
out. Yeah,
Okay. So they've already kind of done that. Okay.
yeah. And so if someone wants to look and see if they find the article, you can post it in chat. It was a
Okay.
pretty good article, and I felt pretty appropriate. KSL's fought some pretty significant grandma battles, and they have been very helpful in getting some records the government didn't want to release, and now they're watching the government
Okay.
go through and undo a lot of that.
Wow. Yay, KSL.
So, yeah, KSL is one of the reasons we got as much information as we did about the AG's office.
Oh, interesting.
They were really into that one. So,
Huh.
but yes, but Jill, did you have anything specific with this one you were curious about?
No, but it made a lot of sense. So I'm wondering on Senate Bill 277, is that kind of maybe not the grandma, but saying, oh, we don't want people to know what's going on in the government, and if they do, we'll just kind of ignore it.
Yeah,
It's
I mean, this one,
protecting
sorry, go ahead.
it's protecting the government employees rather than getting prosecuted, they can resign.
Yeah, there's that bill too, right? That Mikkel proposed. That you can't be prosecuted if you resign. That's, to me, outrageous. So do whatever you want, and then if you get caught, just resign, and you're good to go. I think that's pretty wild that we're even discussing that when we're talking about, making elections more secure. Okay, again, then they do all these other things of, yeah, as long as you resign, we won't come prosecute you.
What number is that?
I saw the bill. I don't have the number exactly.
Let's see,
Jill, do you
is
know?
it an SB 277?
No, that's the one we
Oh,
were
it's a
just looking
Senate,
at.
it's a Senate bill. It's
Let's pull
SB
up.
277.
Let's pull up Mikkel though, because he's the one that sponsored it. I think he's the one that sponsored it.
Oh yeah, it wasn't 277. What was that bill?
Maybe he wasn't.
Let's see, I can look here.
Yeah, Jill, if you want to try and find that one.
Yeah, I think it is SB. No, never mind. Where did I see that?
It's not 277. I just
No.
saw it too, but I didn't tab it for this discussion.
Let's see if I got it over here.
Hey, maybe Jill will find it for us.
Yeah, I'll kind of look. Oops.
So we'll go on for a second though while Jill looks at that. Now this is one other one Jill had asked about. And this is HB 483. And it's proposing modifications to the school and institutional trust lands. Now these, if you don't know, Utah has this huge fund of money, lands that generate the income they generate. Some of the income they generate gets sent to schools. And so it's meant to be this fund to help Utah have schools funded for quite some time. It was set up when Utah became a state as part of the contract Utah had with the federal government. And I mean, it doesn't look like this bill is moving super quickly. It's still in the House Rules Committee after 5 days. And so sometimes they do that waiting till the end. But this one has a number of things, and I don't understand the school trust lands enough to know exactly what's going on here. But some of the things that they are doing here, they go through and create some, I'd say they make the definition more specific for what a primary beneficiary representative is. They add some things like the designee of the State Capital Preservation Board and things. And so they expand that, but if you go on down, so they also put in that you're supposed to kind of do an audit every 5 years, estimate the value of no less than 10% of the administration's land portfolio, so they're holding land. I'm not concerned about an annual report. I think there should be an annual report done. But you start to get down here and you start to look at what might be going on. And again, this gets concerning with all the development, all the inland port stuff, all the Ryan Smith hockey type stuff. It says the director shall offer, so shall means they have to, for sale any trust land. So this bill is proposing to start to require the sale of certain trust lands. It says if they're subject to a valid lease agreement, so these lands are leased and they make money off the leases to then, again, give to the schools. But it's saying, hey, if you have a valid lease agreement or permit, then you sell it to the owner of that lease or permit if the director approves the sale of the trust lands. And this says the owner of the lease or permit agrees to pay fair market value, which may not exceed an amount equal to the highest credible offer received for the trust lands. So they're putting a cap on what you can sell it for. This money is supposed to be going to schools, but they say, we're going to cap you on what is possible to sell it for. One, you have to sell it if it's subject to this valid lease agreement. And if they've held it for at least 25 consecutive years, the lands are not greater than 640 acres, and the lands have basically been fenced off. There's not an authorized point of public access. I have no idea how much land is subject to this that they're looking to start selling. But again, when you are talking about putting a cap on what people can pay, the government, I believe, if they are going to sell something, should get the highest and best value. I don't know why you'd cap it. But I am concerned that we're going to start selling off our school lands to these people. Again, they're supposed to be generating money from the leases. And they'll certainly generate some money from the sale for a time. But they go through, they take out some of the things that the director is supposed to do. And part of that's because they're changing the office. And so they take some things out and then they put it in. But when you come down here and you look at all these things being repealed that they don't talk about, you kind of go, wait a minute. What are they taking out? And so you go over to some of these, and we're looking at these right here. And they are getting rid of all types of things. There's this advocacy office that advocates for the interests of the beneficiaries. And they've completely gutted this advocacy office. They said, we're not going to have anyone that cares about the interests of the beneficiaries anymore, really. We're going to get rid of it, which maybe that's part of, they felt it was wasteful. Maybe it's part of streamlining the budget. There's arguments for that. But we just take out this whole office. And this office oversees the activities of the advocacy director. They work with the state treasurer. They had these 5 members. And they went through qualifications, all that kind of stuff. And again, this is all, if this goes through, this would all be gone. And so curious if any of you had thoughts or concerns on that. Jill, I know you had brought it up as well. Just want to make sure we address any points that you had with it.
Are you still there?
Yeah.
Okay. No, I think I just have concerns when they start messing with that kind of stuff. I think a lot of school districts have big balances, and I don't know if that's where it's coming from. And I think that's my main concern. They always play with what they shouldn't be playing with.
Yeah, and again, to me, when they start saying, okay, you shall sell it, and we're going to put a cap on what they have to pay, which is just the highest credible offer. So everyone knows, don't offer much. We put it right there in code. If you offer it, you're going to shoot it for everybody, destroy it for everyone. And you go, wow, this is, I don't know. I don't believe things like that just get drafted accidentally. I believe they're very much there, which then to me says, who wants this land? I don't know. But I start asking those questions.
So what's the purpose again? Why is it to generate, it's just to generate money for the schools, so they're going to sell some land? Do they need money? What's the motive?
The theory behind, well, we don't know the motive. They don't tell us that. The theory behind the school trust lands is that from the contract Utah signed with the federal government, they would have this fund that held these lands that would be used to generate income for schools. And the fund's grown huge, so it's massive right now. To Jill's point, maybe it spits off too much money. I don't know. I don't know everything going on with this. But again, I go, it's one thing to say it's so big, we need to start liquidating some of it. We don't need to control all this land. Okay, maybe that's true. But why in the world would you put a cap on it? Because that's money that could be used to lower income taxes. If people are buying lands out of this thing, you can send that to the schools. And so, again, when I see things like that, it makes me not believe this is for a pure good reason necessarily.
So we have so much land that's benefiting the schools, so the schools should be swimming in money. Is that what I'm understanding?
Well, kind of. The fund has grown huge. There's a crazy amount of money in it, but they only permit so much to be sent to the schools. It's supposed to be a perpetual fund that keeps growing and growing and getting bigger and bigger.
Okay.
Which again, I have some concerns with from just a normal check and balance perspective of, should our government be holding billions and billions of dollars just for who knows what? I don't know. And then we restrict. And so we had the constitutional amendment last election. Should we increase it from 4 to 5% distribution? And that passed. But that's still only 4 to 5. That went from 4% to 5% of the profits. So we're not talking about the principal in it. We're talking about the profits it generates. We're only taking 5%. We're reinvesting the other 95%.
So why are we paying property taxes if there's already money being generated for
crazy
schools?
amounts of money? Yeah, lots of money. It's a good question. And now again, it's, well, let's sell it for a low cost to these people that have held this for 25 years, I guess. So kind of curious there, but Don or Petra?
Yeah, I'm just curious, is there any provision? I know that it's mandated that the leases need to go into this fund, but is there anything that says if they sell the property, the money has to go into that fund?
I don't know what the law currently is, but based on what the federal government required, a certain portion of it had to go in if they sold the land. So I'm pretty sure some of the money would make it back there if they sell it. But I don't think the federal government required them to put it all in.
Yeah, so I'm just wondering if this is just an effort for them to find some more funds for something else. And, they figure, well, we got all this money in this fund. We can sell some of this and use some of the money for other things.
But again, I would say if that was the case, why not take the highest and best offer? Why cap it?
Yeah, that part is, I don't know if they're protecting the people that had the lease. Yeah, it sounds like they're giving them the best opportunity to buy the property. And, I don't know if people that have been on there all that time, they're probably giving them the opportunity to keep it, but I don't know. Other than that, I have no idea.
Yeah. And that maybe that is the intent, is to say we don't want to price out the people, but the provision says currently they can only sell to the person that's on there. They can't sell to anyone else. So they already have the protection again to say, well, we're not going to let someone else come and get you out, but we're also going to cap what we take. I don't know.
But what happens if the leaseholder doesn't want to buy it? Because it says he shall sell this. If they don't want to buy it, then they just continue leasing.
Yeah, they continue leasing.
Okay. Yeah, I have no idea then. It's kind of weird.
So these lands, did you, they're state lands? This is state land, not
This is
federal land?
state, not federal. Yeah.
Okay, so the federal government they control the majority of our land, so this is just whatever land is left. Is that what is that right?
Yeah, so the federal government every once in a while will spit off lands to this fund. And so over the
Okay,
100+ years we've been a state, they spit off lands to it. If the federal government sells stuff or does certain things, they're supposed to spin off a certain amount to the fund and things. And then Utah too. But it's grown, it's huge. But Utah does control a lot of lands, and they make money off of that as well.
okay.
So, and they wanted to control more. We saw them try and get that land from the federal government with their lawsuit that the Supreme Court denied, but they wanted to see control of a lot more land. And so that's something that's happening. And again, I go, is this pure? Is it private developer? I don't know. But Brian, do you have thoughts on it?
Yeah, I'm a little surprised that this is the first time I'm hearing about a massive fund for education. I feel like I'm pretty involved, and this is the first time I'm hearing about it.
Yeah, I learned about it the first time I ran for the school community council when my kids were in elementary, some of them. And we were tasked with distributing the funds that came from this fund.
Okay.
And that's when I learned about it.
Do you know how much, that 5%, do you know how much that is? Like what kind of numbers we're working with here?
Yeah, Utah reports it. So let's see. Utah school trust land disbursement. They have the Trust Lands Administration. Did not get a quick ChatGPT answer. But it's all here. I mean, they've got their sales and leases, energy, whatever. It's all there.
Trust Lands Administration. I'll check that out.
There you go. Well, since 1996, they've generated 2.07 billion.
Okay. And I assume that only goes to public schools. It doesn't go to chartered or private.
Chartered may get it because chartered gets a lot of the same stuff, but private no.
Okay.
But I'm not sure on chartered. I know they get lumped in with public on a lot of things though.
The intent's really confusing here. I'm really confused with what's like. It almost feels like a clumsy attempt to hamstring the education in favor of private and charter. That's something that they used in the South as a strategy. But I don't know. This is weird.
Well, and to that point too, which is an interesting one. When Utah passed the Utah Fits All Scholarship and said we're going to give money to private schoolers and homeschoolers, the express intent of the sponsor of the bill was to hamstring public education. He wanted to create intense competition and make it so that way more people could leave the system and go into private and homeschool.
Yeah.
And so if others had that same, thing, I could see that. Because they've gotten upset at the public system.
Argument that tying education to property taxes itself is an attempt to hamstring public education.
Yeah, and there's a lot about creating unequal results across demographics and things by tying it there as well.
Oh, that's interesting. And this is who's the sponsor for this bill again?
This one is, let's go on up. Neil Walter, Representative Walter, 83. And again, I haven't had time to reach out to him to say, what in the world are you thinking? Status-wise, I don't know if one this big is going to get through. It's still sitting in House Rules Committee, so it's not even been scheduled for a House committee yet, and it still have to go to the House committee and House and a Senate committee on Senate. But if it's one of the bills they really want to get through, then they generally will suspend all the rules the last 2 or 3 days of the session and just skip committees and just pass whatever they want. So you can't fully rely on the fact that timing's a little off. And sometimes what these people do is they put them in with the goal of getting it into interim so they can talk with people about it for a year and do their willing and dealing and then run it through next session. So that's a strategy as well. So this could be, maybe they don't want it to pass this year, but maybe they want it next year. I don't know. But it is one to look at for sure. Trying to figure out what's going on. Okay, and then Maria, you had asked about the Todd Weiler's bill on state debt collection amendments.
Mhm.
And curious if you had specific questions on this or just wanted to look at what it was doing.
I just saw somebody reference it and just said they had big concerns, and I just was curious to see what you saw there.
Okay. So right now in Utah, if you go to, let's say, the University of Utah Hospital and you don't pay your hospital bill, you will actually have the Attorney General's office coming to collect from you. And the Attorney General's office has a collection arm. And since the University of Utah Hospital is considered a state hospital, that medical debt is considered a debt to the state that they collect on. And the University of Utah Hospital is generally one of the more aggressive healthcare collectors. They're not super kind compared to others. But there's a lot of other places that they will collect. So another one, and this one talks about it quite a bit, is that when a person passes away, if that person had been on Medicaid, Medicaid in theory only covers situations if you're too poor to pay for healthcare services. So the issue came up with Medicaid is that if you owned a home and there was a bunch of equity in it, then you were considered to not be too poor for Medicaid. And people had to sell their homes to qualify for Medicaid, and it was considered unjust and whatever. So over time, the government changed it to say, okay, we'll let you keep your home if you go on Medicaid, but we're going to slap a lien on your house, and everything that Medicaid pays out, we're going to take out of your equity when you die. And so anyone that's on Medicaid can have, if you're trying to build up equity in your house or anything like that, you can have these liens sitting on it that make it very difficult to ever break out of that poverty cycle, essentially. Most people don't understand that about Medicaid. The government does try and collect back what it pays in Medicaid if they can. And so a lot of this is dealing with the Medicaid stuff, which is why
Interesting.
they have this stuff talking about the decedent's estate. The decedent's the person that passed away. So they're saying that there was already a notice required. If the person was over 55 when they passed away, the probate courts would send notice to this office to collect, or to say, hey, this person passed away. Do you have a claim to make against their probate estate, essentially? This bill proposes to lower that age instead of it being at 55 to start at 18. If you're over 18 and you pass away, they're going to send a notice that you passed away so they can come seek in Medicaid collection if necessary. And there's a couple other things it's doing here. You can see here where we talked about the office shall. So these were duties this office had. They were supposed to provide information, training, and technical assistance to each state agency. They were supposed to help develop consistent policies. And they were supposed to help have automated cash receipt processes between each state agency and a bunch of different things. They're taking these out and they're moving them down to the may section, which means it can choose if it wants to do some of this stuff. And they didn't pull all of them down though, but they may provide information and training if they want to, but don't have to if they don't want to. So that change to me was a little unique, going, okay, apparently someone's upset that they're doing this and they're trying to change it somewhat. This one though is one I do have a lot of heartburn about. They were allowed before to make rules that allow account receivables to be collected over a reasonable period of time, and potentially with people paying with credit cards. I'm not necessarily opposed to getting rid of credit card payments, people transferring one debt for another. But if they take away your ability to get on a payment plan to pay your hospital debts or whatever debts, they're already pretty aggressive as it is. And I just went, I really don't like taking out that they can no longer let you pay over time. They're just going to come out and try and take everything. So this will, what this does, this pushes a lot more people to bankruptcy because they can't work out a payment plan and they have to declare bankruptcy essentially to try and protect their assets and things. And then they also add in here that the debt collection office can actually foreclose on and take title to real property, which they couldn't before. So now they can take your real estate from you as part of this, which again, when you look at these two things together, you can no longer pay over time and you can now take real estate from people. I go, the government wants more real estate. Maybe I'm wrong in that, but that's certainly the way it looks, those two things together. And again, there's so many games with real estate right now, so many things I don't completely track or follow with everything that's going on. And so this is talking about the notice thing. See, there already was a notice provided when you were over 55, but now they're changing it to 18 years old and 55 years old. It goes to slightly different people, but they'll still send notice. So if you have to file in probate, that notice is getting triggered. And most of that's for medical, but there's also child support. There's all kinds of things that they're checking to see if you owe. And then, yeah, this is just clarifying that they can still do their normal collections with criminal accounts and restitution and stuff like that. So it's not, it's not, again, I guess to say on the real estate side, this one's saying if the government gets a judgment against you, a lien suddenly arises against all real estate you hold in the state. And then they're authorizing them to foreclose on that lien, hold real property, and they're taking away their ability to do a payment plan. So you can't say, okay, I'll pay you over time. They're like, nope, you owe it all today, interest, everything. Oh, you don't have it. Oh, we're going to take your real estate from you. So that's, to me, it appears to be something where they want more real estate. And again, maybe they have something where there's tons of debtors that hold all kinds of real estate and they're not paying their fair share. I don't know exactly what the genesis of this is, where it came from, but that is, that's the main gist of that bill. Brian?
Yeah, I'm really curious why this can't be pursued by a private debt collector, why it needs to go into the public sphere. Are they tying any criminal statutes to medical debt to justify that?
Nope. Nope. We've had a state collection agency for quite a while. The theory is that because it's a debt owed to the government, you went and got healthcare services from the government. You have to pay the government, and so the government enforces it, is the theory. I'm not saying that's right, just that's how they justify it.
And I mean, the Attorney General's office is primarily funded from the taxpayer or their own wins. I'm not actually sure how the Attorney General's office is funded.
It's all from taxpayer funds, yeah. Because the
Okay.
funds they collect are given. So if you go collect medical debt owing, it's sent back to the hospital, not to the AG's office.
So instead of pursuing corruption charges, they're going to be pursuing the debts of people that are impoverished.
Correct. Yep. And taking the real estate.
Yeah, I could see. I'm curious if there's any laws on the books that would allow, let's say, a developer that owns a specific percentage of a city block they have default jurisdiction once they hit a threshold, so they could get rid of single family housing a lot easier. I don't know if there's anything like that.
I don't know of anything like that. But what starts to happen on the public-private partnership realm is once you own a certain amount of real estate in the city, then the city starts negotiating with you over what they do or don't do. And you gain a lot of power just simply because you can say, well, I own it, I'm going to do this or that or whatnot. And a lot of people got really upset since the Church of Jesus Christ owns so much real estate downtown. When they wanted to take over Main Street and put the plaza in, there were all kinds of lawsuits over that. People up in arms going, look, you can't just give a street to people. And that one, I'd say, from what I can tell, was because they were such a large landowner that it's tough for the city to say no because the city needs them as well to cooperate on a bunch of things. So that you certainly gain influence. And we can see that with Ryan Smith getting $1 billion sent to him from taxpayer funds in Salt Lake City. It's to redevelop downtown. And he's going to do it, but own it all in the end. And so it didn't give him the ability to just have jurisdiction and, say, I just get to declare it. He still had to get the rubber stamp of city council, but it was a rubber stamp on what he wanted, from what I can tell.
So on surface level, it looks like an attempt to use taxpayer funds to weaken the taxpayer position in our general society.
Yeah, it's certainly one way to look at it. And when I look at it, again, the provision that removes the ability to make payments over time, I just go, that's horrible. Almost anyone in debt needs the ability to make payments over time. That's just the nature of debt is, I can't pay the full bill today, so we gotta pay it over time. I'm gonna work something out with you. That's what almost all debt collectors try and do is they reach out and say, can you strike up a payment plan with us type thing.
Yeah, that's really, I mean, it does, like the bankruptcy seems to be the point with this bill.
Yeah, and then again, they get a lien immediately. So if it goes to judgment and they get the lien, then they have a lien on your real estate, which allows them to take it, and they specifically authorize them to take it. And again, I just go, we have so many issues already with housing and real estate being bought up by all types of people, and now we're potentially losing more. And if you read about medical debt's the #1 cause of bankruptcy in America.
Yeah.
And so all these people that have medical issue arise, they go up to the University of Utah, and then they're suddenly subject to losing their real estate over it. And and then they're getting more aggressive about saying, we want to come after anyone 18 or older that might own anything, send the notice up here. I don't get good feelings looking at this, thinking that they're doing this for our benefit necessarily.
No, I mean, it feels like they're criminalizing debt, not explicitly yet, but it feels like it is going in that direction. which, I mean, it feels like an explicit return to feudalism.
Yep. So that's one to be aware of. So thanks, Maria, for pointing it out. Again, little changes, but with huge implications in practice. So then we have a few constitutional amendments on the books that they're proposing. So I wanted to quickly look at some of those. We have one from Representative Coford about property tax. This is a pretty simple amendment. Currently, the government is authorized, or the legislature may, by statute, this is under the Utah Constitution, exempt the following from property tax. So they can exempt up to 45% of the fair market value of residential property. So if you look at your property tax bill, it'll show you the full value of your property, and then it'll show you the amount they're paying tax on. And the amount you're paying tax on is 55% of your fair market value of the house. This is proposing to increase that so that they can exempt 55 and only tax you on 45. That in theory is a great thing. I fully support exempting us from property taxes, but our houses have gone up so much in value that they won't lose $1 over it, and we won't pay less in property taxes. They'll just impose this at a time when they increase our rates or increase our home value, and they're going to take the same amount still. So, but again, cool, I guess, exempt 55% instead of 45%. My bet is that would pass if it went to the people. But I don't think it will save us anything in effect with the way things are going. The right to work one, this one I have a little bit more beef with. Utah passed the union bill prohibiting public sector, so government employees can't unionize, or they can unionize, but they can't, the union can't negotiate with the government. The government's not allowed to sign a contract with the union. So it effectively is killing government unions. And so I don't know if they're trying to throw them a bone with this one back, but they're proposing to add in the Constitution something that regulates the private sector, including the government, but it says it's unlawful for any person, individual, corporation, or association, or the state or its political subdivisions to deny employment to an individual by reason of the individual's membership in, affiliation with, resignation from, or refusal to join or affiliate with any labor union or employee organization. So you can't not hire someone if they're part of a union, and a union can't not hire someone that's not part of the union. So in theory, you could have an individual working for a union that's not part of the union with this. And my personal feeling is in Utah, unions are so small, very few of them have the power to demand that you join the union in order to work. I don't know. Going back to the first one we talked about, HB 441, I just kind of go, I think we should keep this more private and if a company really wants you to be part of a union or doesn't want you to be part of a union, I don't know. I like private rights more, but that one's there. And then we'll try and go quick since we're getting done here. Publication amendments. I did fully expect this one. One of the reasons that 2 of the constitutional amendments got struck down is because the Utah Constitution required that they publish these in at least one newspaper in every county of the state where a newspaper is published for 2 months. And he's proposing to say, let's just do it. We have to publish it, so you have notice of it. We have to do it for 60 calendar days. So that could or could not be 2 months, depending on how the months break. But we want to do it in a manner provided by statute, which means the legislature gets full control over the manner. Which could be that they just say, oh, we put it on one obscure website somewhere. I'm okay with giving some flexibility to the legislature for changing times, meaning we don't use newspapers anymore, so maybe there should be something. But I wouldn't mind something that says in a manner provided by statute and that is calculated to reach the most number of voters or something like that. But I did expect them to try and chop out the newspaper requirement.
So what is this pertaining to? Notice, is it just any government notice?
This is specifically for an amendment to the Constitution, sorry. So if they're going to
Okay.
amend the Constitution, you get a vote on it when it comes at the election, but the Constitution said they had to publish it in the newspaper for 2 months prior to the election. Now they're saying we have to publish it for 60 days prior to the election, but we get to choose how we publish it. With no, it's just wide open on how they publish it as long as they do it for 60 days. And so my bet is it'll just be on some government website and people have no idea about it until election time. Which, to be fair, is about the same right now as with the newspaper. Because people aren't seeing that in newspapers either. This one's interesting. We looked at this one at the start, and what this one said at the start was, if they're going to impose a new tax, then you need 60% of the voters. And I was interested to see that they've filled it out more since then. So this is a statewide ballot initiative. So if the citizens propose a law and the legislation includes the imposition of a new tax, an expansion of an existing tax to include additional items or transactions subject to the tax, an increase in an existing tax rate, or for a property tax, a change to the tax rate that causes the tax rate to decrease less than it would under current law, then it has to be voted on by 60% of the people is what they're proposing instead of 50. I really laughed at this one. They wanted to make it very difficult for us to decrease our property taxes by a ballot initiative. They like those property taxes. That was not in there originally. And they've added that one in. But so that one's a proposal. And then one last one before I wrap up. This is coming back to Brady Brammer. We talked about SB 204 last week. The Utah Bar took a position against SB 204. They try to stay out of most of these, but they did come out pretty hard against SB 204. He did propose a change to it that made it so the government could not enforce an unconstitutional law while it was on appeal, like he was proposing. But he has this instead now, which says that if you want to try and get an injunction against a state law because it's unconstitutional, he says that you must file the motion within 28 days after the legislature ends session. So back to Brian's point about feudalism and things, there are incredibly few businesses in America that have enough money to watch every bill that comes out of the legislature, have a constitutional review of it, hire attorneys, and get it filed within 28 days of the legislature ending. That's very difficult to do. Even companies like Facebook struggle keeping up with that just because of the sheer volume of laws in every state and stuff they're trying to watch. But that would effectively make it so only the most well-funded, most on top of it companies could protect their constitutional rights, and the rest of us wouldn't be able to. So I'm not a fan of this one at all, and very opposed to things like this that limit our ability to take constitutional claims to court. And I say, well, Brammer, stop passing unconstitutional laws if you're concerned about this. Don't try and restrict us to 28 days to file things.
Can you give a quick example of that?
Yeah, so let's say that Utah passed a bill that said we want to, we're now going to require that anytime you enter a venue, they scan your driver's license and it gets transmitted to the state immediately. So we know where you are all the time. And people go, whoa, that's not constitutional. That's a Fourth Amendment violation. But the bill just kind of goes through quietly. It makes it through, let's say, the last day of the session when there's a million things going on. But it doesn't have an effective date for 2 years. So no one's even watching it because the effective date's 2 years out.
Got it.
And then if you don't file, he's saying if you don't file a lawsuit challenging the constitutionality of that within 28 days. So again, imagine being a citizen and going, oh, I have to get money together for a lawsuit. I've got to get an attorney on board. I've got to get the lawsuit drafted and filed. In that time, I have to have a strong enough idea to know it's constitutional or not. Most people don't immediately know if something's constitutional or not. And when a law comes down, they're usually not so blatantly unconstitutional, like the example I gave. But that is something that happens, and you have to look at and say, wow, so somehow we have to be able to be hawks watching, know immediately if it's unconstitutional. We don't even get time to sort through it, and we've got to get our ducks in a row and get a lawsuit filed within 28 days.
Wow. Okay.
And I go, that's crazy. Crazy. Even if you came to an attorney and asked them, you had all the money necessary and you said, can you have this constitutional challenge ready to go in 28 days? Very few attorneys have the bandwidth to turn that around in 28 days. And that's even without asking them for advice on it or anything, just saying, we've done all the work on it.
So if you don't have a legal team working on constitutional challenges, or let's say a friend in the legislature, is going to be very difficult to challenge.
Correct. And it's just back to your point of feudalism. The elite will be able to protect their rights that they're concerned about. The rest of us will have an extremely difficult time because we'll have missed our 28-day window under this.
How is that working? Is it favorable? Is it looking like it's going to pass?
So this one only came out 4 days ago.
Oh, okay.
So
No.
again, so what happened was the bar came out with opposition to his 204 bill, which said that the government can enforce unconstitutional laws while it's on appeal. And because of the opposition against that, and it really wasn't a defensible bill, he dropped that and changed it. But then he introduced this. And Brammer is decently, I don't know, powerful is the right word, but he's got sway in the Senate. So could he get it through still?
Didn't he
I
just get
don't
there?
doubt he could.
How did he get sway so fast?
Well, he was in the House. He was pretty well respected
Right.
in the House, and then
Okay.
he jumped over to the Senate when the seat opened up.
Okay. Didn't take
So-
long for him to get footing there then.
No, and again, the House and Senate are so small. He was definitely one of the movers and shakers in the House. So the whole Senate knew him. He already had all those connections. There was no
Yeah.
need to develop anything.
Got it.
So would I doubt that it could go quickly? I don't doubt that. I know that Brammer has a big beef with the courts. But this is his response to the bar's opposition to him. He says, fine, we'll give you 28 days. So, but to me, an important one to know about for check and balance purposes of saying we need to push back on this one. And that again is SJR 9, Senate Joint Resolution 9. So we're slightly over. Sorry about that. But any other questions or things today before we wrap up?
Thank you so much. So helpful.
No, we'll just meet next week. Next week will be the last one because then it just gets into the wildness of the last week when they suspend the rules and whatever. So, so hopefully you guys can join us then.
Appreciate it so much. Thank you.
Yeah, thanks everybody.
Thanks, Austin.